Hello, everybody. Look who we've got here. We've got Nuggets with us. Say hi, Nugs. Yes. So Nuggets, the famous kitty that is part of the famous music videos that you've seen. Have you guys heard my country song which is about me driving around and having Nugs with by my side? Yes. So this is the famous Nugs. So yes, hello everybody. Welcome to the live stream. And today we're going to talk about nasty stuff. We're not going to talk about nice, cute things like nuggets. We are going to talk, unfortunately, about things that might spoil a contract. So we're looking at our vitiating factors, things like misrepresentation, duress, undue influence, mistake, illegality. So all of that nastiness is going to come out. So I would like to say hello to everybody. We got a couple of people joining us live, which is amazing. Thank you so much. And I would like to say thank you to our new channel members, because we've picked up a few channel members last week, which is amazing. These are the people who are willing to buy me a flat white for $2.99 a month and support these efforts that we're making here. So thank you so much, guys. So I'm going to attempt to do stuff, but considering that Nugs is just sitting on my arms here, it might undermine a little bit my ability to share my screen. But let's try. So are we all ready for some contract law? Yes, we love the subject, right? We love it. I don't know. Do you guys find it easy? Give me a line in the chat about how you feel about your preparation for contract law. Now, if you just happened upon this live stream by mistake, this is not a pet live stream. This is just an extra actor here. The live stream is primarily for those poor souls preparing for the SQE, the Solicitor's Qualifying Examination. So today we're dealing with FLK contract law, and specifically the types of things that might spoil a contract. So if you guys are up for it and you're enjoying this, hit the like button and drop a line in the chat to let me know how you're getting on. Right, now what I'm going to do is attempt to share my screen so we can read out the questions together. Let's see if we find this. Oh, Maria says there. Hi, Maria. How are you doing? Yes. So, well, the thing is, what worries me sometimes about contract is that it seems approachable and it seems manageable, and precisely for those reasons, people don't devote enough time in their preparation for it, which then runs the risk that when you get to it, you might be a little bit less prepared than you think, and then run into trouble. So, hopefully, what we can try and do through these sessions is to remind ourselves of some of the basics, so then we are on top of this material and we can respond to the MCQs we're going to find in SQE1 effectively and quickly. So then we have a little bit more time to think about more complicated areas for the law, or perhaps areas of the law that we're less familiar with. All right, so hopefully you can see me at the bottom of the screen, Nuggets here sitting on my hands, and the PowerPoint presentation in the background for our weekly live SQE prep. So let's get going. So we have question number one. In question number one, let's see what's happening here. Liam is looking to buy a used van for his courier business. He visits a dealership, Drive Safe Limited, where a salesperson tells him that the van that he's showing him has never been in an accident and has a brand new engine. And this engine was fitted in the previous month. On the basis of these statements, Liam purchases the van for £12,000. A few weeks later, however, Liam experiences engine trouble and takes the van to the car shop, and he is informed by the mechanic that the engine is in fact 3 years old and the van was involved in a major accident in the previous year. Liam is pretty pissed off, so he contacts DriveSafe, but they refuse to refund him. They say that the salesperson genuinely believed the statements were true at the time of sale, therefore they are not liable for anything. So the questions. What type of misrepresentation is most likely involved, and what remedies are available to Liam? Is it A, Fraudulent misrepresentation. Liam can claim rescission and damages as the salesperson knowingly made false statements to induce him into buying the van. Is it B, negligent misrepresentation? Liam can claim rescission and damages under the Misrepresentation Act 1967 as the salesperson failed to take reasonable care in verifying the van's history. Is it 3, innocent misrepresentation? Liam can only claim a rescission as the salesperson believed the statements were true at the time of sale. Is it D, no misrepresentation? Liam has no claim as the statements were made in good faith. Or is it E, breach of contract? Liam can sue for breach of contract because the salesperson's statements automatically form part of the contract. Okay, so what do we think? Are we talking about misrepresentation? Are we talking about breach of contract? And if we're talking about misrepresentation, which one should it be? Feel free to stick your potential answer in the chat, and then we can see whether we agree with each other or not. Or, if you don't want to venture a potential answer, then just stick an emoji in the chat to see how we feel about it. Let me see, what do we have here in terms of emojis? Oh, channel members can also put special bespoke emojis. Check this out. Yes, we're full of tips, tricks, and tips and everything else. Okay, so what do we think? Which one are we gonna go for? The correct answer, let me just move Nugs and pick up my notes. Come here, Nugs. Yeah, oh, he's upset now, he's leaving. All right. So what is our correct answer? Our correct answer here is B. We are talking about negligent misrepresentation. Right, okay. What do we need for misrepresentation? We need a false statement of existing fact that induces the other party to enter into the contract. 4 things, okay? False statement, fact, inducement. If we got those 4 elements, then we can deal with the topic as a misrepresentation topic. If we don't have them, then it's not misrepresentation in something else. Perhaps a primary thing to think about is how do we distinguish between misrepresentation and breach of contract? Because they tend to arise out of similar circumstances. And to be honest with you, it is something that has always puzzled students. My sort of traditional first-year undergraduate students that are doing contract law, they come across both breach of contract and misrepresentation, and they have difficulty distinguishing one from the other. There's good reasons for this, but I think the way to split them up is to stick to these criteria. If you're complaining about the breach of contract, you're complaining about promises that have not been fulfilled. What does that mean? It means that somebody is saying that something will happen in the future as a result of the contract. This is not the case for misrepresentation. Misrepresentation is not about future promises, it's about what's happening right now. That's why in the four requirements I gave you, I said false, but statement. Why statement? Because it's a statement and it's not a promise. So if what you're complaining about is an unfulfilled promise, then you are in the domain of breach of contract. If you're talking about, however, background information that is false, then you're in the domain of misrepresentation. So I think that kind of helps us nail this in the area of misrepresentation. So we are talking about a false statement. Why? Because it was information about the state of the car and it is not correct, right? And it's a statement because it's about the existing state of the car. It's not promises about its performance in the future. It induced the other person to enter into the contract because Liam would have not bought the car if the information that he received as to its state was different. Yeah. So false statement, existing fact leads into the contract. Next level question is, what type of misrepresentation? When people are lying to you, somebody's trying to cheat you, then we're in the domain of fraudulent misrepresentation. Now, fraudulent misrepresentation applies if the statement is made knowingly or recklessly without any evidence in its truth or belief in its truth. So this comes from the case of Derry versus Peak from 1889, meaning that somebody really doesn't care and is trying to cheat you. Innocent misrepresentation, so fraudulent we had in A, innocent we have in C. Innocent is when somebody makes an innocent mistake. Negligent misrepresentation is when they don't have reasonable grounds for believing the truth of the statement. So we're not talking about people who are trying to cheat you. We're just talking about people who don't care enough to verify the sources of their information. Why is it important to distinguish between the different types of misrepresentation? The reason is that the outcome is different in terms of remedies. Now, what is the primary? I talked to you about the differences between misrepresentation and breach of contract, right? Let's go back to this. What is the primary remedy for breach of contract? The primary remedy is, I was looking to see if I've got any money here. I don't. Money, right? The primary remedy for breach of contract is damages, which means a monetary sum in compensation. Fine. What is the primary remedy for misrepresentation? The primary remedy is rescission, meaning you get out of the contract. Now, you may have heard the term termination as well. We use the term termination for breach of contract, but then you have the right to stop. We use the term rescission for getting out of the contract for reasons of misrepresentation. Now, it gets a little bit technical, but you come across these terms as you're going through the literature. Now, the primary remedy for misrepresentation is rescission, but in some cases you can get damages on top. Which are those cases? Fraudulent and negligent misrepresentation. We know for fraudulent because we got a great deal of case law. We know for negligent because of the Misrepresentation Act of 1967. Innocent misrepresentation entitles you to rescission, but not to a monetary award of damages on top. So for practical purposes, like trying to advise Liam, we have to figure out whether it's misrepresentation or breach of contract. But in addition, we have to figure out what type of misrepresentation we're talking about. This is important. It matters in the consequences. It matters in the argument you're putting through. So, conclusion. The conclusion is that the correct answer here is negligent misrepresentation, because the question does not give us any evidence that the salesperson was intending to cheat Liam. They just didn't care enough to figure out, to verify the sources of their information. So again, remember, why are we doing this? We're looking at multiple choice questions in the context of the SQE. You will be provided with a lengthy scenario like this one, and then a bunch of chunky possible answers. Your job is not to find the one correct answer amongst a bunch of totally irrelevant ones. Your job is to find the answer that is most plausible, the one that matches better what the question is asking. So it's entirely possible that you've got a variety of questions that could potentially be correct, but your job is to find the one that is the best one. So even though we could make arguments for some of the other options here, the best possible option is the one that says negligent misrepresentation. Okay, how are we doing, guys? Are we good so far? If this makes sense to you guys and you're enjoying it, hit the like button. Or if you're watching this on the replay, again, hit the like button and give us a comment down in the comments box to see how we're getting on. I saw like a heart flying around. Thank you. If you're enjoying this so much that you actually want to spend money on it, you can also send me a super chat. It's the thing with a dollar sign next to the chat that you can contribute to my coffee drinking efforts by actually sending me some money through YouTube. Okay, are we ready for the second question? Let's move on and deal with yet another unpleasant aspect of life in contracts. Okay, scenario 2. Ella owns a small clothing boutique and enters into a supply contract with Fashion Techs Limited to receive regular shipments of designer fabrics for £20,000 per month. Halfway through the performance of the contract, Fashion Tex informs Ella that unless she agrees to increase the monthly payments to £30,000, they will immediately stop deliveries despite their contractual obligations. Ella is upset by this. She's worried that she will lose customers and suffer financial losses if she cannot continue the fabric deliveries by these people, and she has to find another supplier. Now, she agrees. After 6 months of paying the increased amount, Ella finds a new supplier and now wants to challenge this modification to the contract, arguing that she only agreed to the price increase under pressure. Right, the question for you. Under the doctrine of duress, which of the following factors will determine whether Ella can claim that the contractual modification is voidable? Is it A, whether Fashion Tex applied illegitimate pressure by threatening to stop deliveries, leaving Ella with no practical alternative but to agree? Is it B, whether Ella has the option to negotiate a lower price before accepting the increased payment? Is it C, whether the increased price was fair and reasonable, meaning that the contract modification was valid? Is it D, whether Fashion Tex intended to permanently increase prices for all its customers, not just Ella? Or is it E, whether Ella continued to pay the higher price for 6 months, as this would prevent her from challenging the modification? Okay. Right. What do we think, guys? What is the most appropriate response here? A, B, C, or D? Okay. Now, you might recognize some of these facts from questions that we've done in the past in the domain of contractual modification. Usually, we've got two distinct legal issues that arise in these types of cases. One is a problem with consideration, because every time we change an existing contract, we need to find new consideration to support the new promises. And the problem with contractual modifications is that the promises need to be balanced. The consideration provided needs to be present at both sides. So one of the common ways in which questions like this express themselves is to suggest a problem with additional consideration to support the modification. It could be that one party is doing something extra and the other party is not. If we cannot validate this through the prism of consideration, and only one party provides what the other one doesn't, then the modification is not valid. Finding new consideration is essential in any validated new contract. Now, what could count as additional consideration here? Well, nothing material, because as you can see, Fashion Tex is doing the same thing as before, while Ella is now paying more money, so it looks unbalanced. But we've got all this case law that we talked in previous live streams. So, go back through our other contract law live streams, and you're going to find the questions on modification. What we said there is that the courts now recognize the idea of what they call practical benefit consideration, which means that even though materially you're not getting something different, the assurance of continued supply, the avoidance of any delays, satisfying your downstream customers can be enough to count as valuable consideration. So just keep this at the back of your heads, because every time we're dealing with this type of scenario, it's quite possible that there is a modification consideration problem in addition to something that has to do with duress. Now, walking it back to the issue of duress. Contracts are supposed to be done because people want to do them. I mean, you might always argue that there's an element of compulsion, right? I mean, I take a job I don't particularly enjoy because I need to pay my rent, that kind of thing. But when it comes to agreeing with the people that are offering me the job, I want to do it. It's voluntary. So, pressure from external circumstances does not negate my will to enter into this contract. However, if I'm entering into a contract because the counterparty is putting pressure on me, then it's something different. So what are the elements that we need in order to support the finding of duress? We need, this is very important, right, an illegitimate threat that coerces the will of the other party, that the party finds no practical alternative but to agree, and that is the reason why they enter into the contract. Does it need to be the only reason? No, there can be additional reasons. It could be that, in fact, this was a good deal anyway, but the motivating reason needs to be the threat from the other side. So we certainly need a threat. Unless you're faced with a threat of some consequence, then we are not talking about duress. But the threat of what? This causes issues normally because people tend to think that somebody needs to threaten you with something criminal. If they do threaten you with something criminal, it's easy. You can always say that, yeah, I mean, this is not going to be a valid contract because somebody is threatening to kill you if you don't sign on the dotted line. Okay, that I understand. But it's important to note that it does not have to be criminal. The threat needs to be illegitimate. Illegitimate is a broader concept than criminal. Of course, any threat of criminal harm will be illegitimate. But other things that are lawful or in any event not criminal can still be illegitimate. For instance, you can breach a contract. Yeah. I mean, it is not a criminal act to breach a contract. You can breach a contract if you're willing to take the consequences. So, you hire, you find like a room in a hotel, right? And it's got a penalty for cancellation of the room. But you found a room that is way, way cheaper. So it makes sense for you to get an alternative room, even if you have to pay the penalty. So you can cancel the original one in breach of your contract with the hotel and pay them the compensation. This is not a criminal act, okay? It's not a nice thing to do because it's still a breach of contract, but so long as you compensate them adequately, you are entitled to do it. There's a whole literature behind this talking about efficient breach of contract, when it makes more sense to breach the contract, compensate the other party, and move on to something else. So that exists. However, it is still considered illegitimate. Even if it's not criminal, it is illegitimate. So we need to find the threat of something that is illegitimate. The threat to breach a contract has been defined by the courts as something that is illegitimate. So then we need to test what exactly needs to happen afterwards for a finding of duress. Cases that you might find supporting these things are a lot of the shipping cases. Now, remember that the shipping cases tend to go with the name of the ship. Yeah. So you've got, for instance, the case of the Atlantic Baron from 1979 that talks about economic duress. So you will hear a lot of kind of boat names. This is where these cases are coming from. So the threat to breach a contract will be considered an illegitimate threat. So then you've got your illegitimate threat. If as a response to the threat, Ella felt that she had no choice but to agree, then you have the elements that you need. In addition, remember that duress does not automatically destroy the contract. Duress renders a contract voidable. What is the difference between voidable and void? Void means dead, it never existed, it didn't exist from the beginning. Voidable, it means that the contract exists up till the point that the victim of the breach goes and complains about it. The distinction is important because voidable contracts have got different consequences than the ones that are void from the beginning. So duress renders a contract voidable. Therefore, the victim of the duress needs to go and complain about it. So a final requirement for a successful finding of economic duress is that the victim in a timely fashion sought to assert their rights and complain. Now, you will notice that suffering loss is not actually a requirement. Yeah, it could be that the deal that they entered into under duress, in fact, is economically beneficial, but this ain't what we're talking about. The requirements for economic duress are threat that is illegitimate, that coerces the will of the other party, and then finally that the victim of the breach complains about it in a timely fashion. From the options that we've got available here, I think the most appropriate option is A. where it says that Fashion Techs applied illegitimate pressure by threatening to breach the contract. And Ella, this is given to you by the question, felt that she had no alternative. Now, the fact that she complains 6 months down the line should lead us to a bit of a discussion as to whether she waited too long. So does she lose the right to complain because she affirmed the contract voluntarily? I don't think so, because she wasn't able to find an alternative supplier to react to this issue. So you could argue that she was still operating under the compulsion up until the point that she found an alternative that she thought she could go with. So for these reasons, I think that A is the most appropriate question here. She was not given options, so B is not correct. Whether the price was fair and reasonable, we don't care, because, as I said, we're not looking for financial harm. We're looking for an illegitimate threat that coerces the will. Whether Fashion Techs had a good reason for increases the prices, again, we don't care. I mean, that's the whole point about breach of contract, isn't it? You have to stick to what you agreed. If you cannot do it, then you're in breach. Nobody's asking you if you had a good reason not to do it. And finally, E is to get you to think about whether she waited too long. But as I said, this is probably not as good an answer to pick as A. Why are we battling to balance the various possible answers? Is because I told you earlier, a lot of them might look correct. So the task that you've got for the SQE is not to pick one correct one in isolation and the others are going to be totally wrong. It is possible that quite a lot of them look fairly correct, and your job, difficult as it is to figure out which one is which. Now, how do you achieve competence in these things? And it sounds a bit difficult. The only way to do it and get on top of it is to try as many MCQs as possible. So for that reason, I would advise everybody to sign on to my newsletter. I send it every Monday. That contains a fresh multiple choice question every week and answers to the previous ones that I've shared, along with resources for you guys to study and so on. The more questions you do is the better it gets. So yes, so Maria in the chat is saying that she's confused by E because it looks like an alternative answer. I absolutely agree with you, but the reason why it's structured this way is to highlight the difficulty that you've got in answering those questions. Many of them, or in any event more than one, might look like a good, plausible answer. And unfortunately, because the SRA does not allow the publication of past papers on the SQE, we don't have the chance to look at the actual questions that they put and then interrogate whether the one that they indicate as the appropriate selection is correct or not. So we're flying blind a little bit on this due to the choices that the SRA has made, but there we go. So the solution for you guys is to do as many questions as possible, to get into this as deeply as possible, and to back up your revision and your understanding of the subject with as much practice as you can get in there. And that's why I think my newsletter is helpful for people. It gives you more opportunity to see questions. And in addition to that, you've got like an articulated explanation as to why the correct answer is correct and why the other ones would be wrong. Okay, are we ready to move on to the next one? Yeah. So you can tell I enjoy the subject. Contract law has always been my favorite subject. Have we changed? Let me see. So we're looking for, we didn't. Hang on. Let's try this again. Okay. Scenario 3. So hopefully now your screen has refreshed. Yeah. Okay. Alrighty. So let's have a look at scenario 3. We're moving to a different set of problems. James is an elderly man with limited business experience and has always relied on his nephew Daniel for financial advice. Daniel convinces James to invest the whopping amount of £200,000 in a high-risk business venture that Daniel is personally involved in. Before making the investment, James expresses some hesitation, but Daniel reassures him, saying, trust me, I won't let you make a bad decision. James wants to maintain a good relationship with his nephew, signs the contract without seeking independent legal advice. You can see how this is getting problematic. A year later, the business collapses. James loses his entire investment. He now wants to challenge the contract, arguing that arguing that Daniel exercised undue influence over him. Yeah, that sounds pretty bad. So the question: which of the following factors will the court consider when determining whether James can claim undue influence to set aside the contract? Is it A, where there was a relationship of trust and confidence between James and Daniel, giving Daniel influence over James' decision making? Is it B, whether James had the opportunity to negotiate the terms of the investment before signing the contract? Is it C, whether Daniel intended to deceive James, as fraudulent misrepresentation is required for a claim of undue influence? Is it D, James's investment was commercially reasonable, as undue influence cannot exist in transactions that appear fair? Or is it E, whether James acted immediately after the business collapsed, as any delay in bringing the claim bars him from seeking relief? Aha, what do we think? Come on, be brave. Stick your preferred choice in the chat. If you get it wrong, I'm going to tell you why. Okay, James and dodgy nephew Daniel. Never take investment advice from family members. Aha. Right. Drum roll. Are we ready? We are ready. So the answer here is going to be A. Whether there was a relationship of trust and confidence between James and Daniel, giving Daniel influence over James' decision making. Now, undue influence is like the poor cousin of duress, because everybody likes to talk about duress because it arises, as we said, in common scenarios like modification of contract. Undue influence is a separate issue that might spoil a contract that sits a little bit on its own in the literature. So admittedly, quite a lot of students miss out on revising that one. But I think it's important to go through it. There are two main types of undue influence. One is actual undue influence, when somebody exercises direct pressure over somebody in the hope that they can influence the decision. And then we've also got presumed undue influence. This is something that arises out of circumstances, when we've got a relationship of trust and confidence, and the transaction that results calls for an explanation. If that's the case, then the burden of proof shifts to the party that is being accused of having been inappropriate. Why? Because this comes from a long line of case law that has to do with banks approving loans, mortgages, and all of that stuff, and the people signing on not doing it because they think it's a good idea, but because they felt under compulsion, either from the bank or from somebody who was advising them. So the two key areas: either we've got actual undue influence or we have presumed undue influence. Now, the case here could possibly work with either of them. I think it's leaning towards presumed undue influence because it highlights the relationship of trust and confidence that exists between James and Daniel. So, why are the rest of them incorrect? B is saying James had the opportunity to negotiate the terms. An opportunity to negotiate does not negate the fact that he might have felt under compulsion. So if his motivation was not to upset his nephew, or not to give the impression that he's not following advice, then even if he looked at the terms of the deal, even if he negotiated a little bit, doesn't mean that he was getting into it out of his own free will. Now, D, so where are we? We were B. So C. C is about intention to deceive. Well, no, because a fraudulent intent or fraud in the relationship would lead us down the path of discussing fraudulent misrepresentation that we did at the beginning is not necessary for undue influence. D is incorrect because As we said, even if the deal is a good one, what matters is that the people are not doing it by themselves and out of their own free will. They're doing it because they're under some sort of compulsion. And finally, E is incorrect because the timing really does not matter here. So a delay does not bar a claim for undue influence. Now, the same situation exists as before with duress, that undue influence and duress make a contract voidable as opposed to void. So the victim needs to go and complain. But I don't think that we've got any indication of a lack of time that would suggest acceptance that would deny James the opportunity to complain about this. So, if the key thing about undue influence is the relationship of trust and confidence that has been violated, then this is the most appropriate answer for this question. Hopefully this makes sense to you guys. I would advise a little bit of care with undue influence and having a bit of a look at all this case law that has to do with the banks and the duties of the banks when taking on, say, joint mortgage holders or joint loan holders. The traditional scenario in the case law is that the husband, say, tries to remortgage the property and then kind of pressures the wife into signing on, either because they're joint holders or because he's a guarantor, and the wife is not doing this out of her own free will. And the result of all this case law has been to impose a duty of diligence on the banks to make sure that everybody signing on has received independent advice. And this comes from cases like Ettridge and so on. The only way that the bank is going to be safe, that they're not caught into an inappropriate setting, is to ensure that the other people got independent advice. Of course, the quality of this advice might vary, but the requirement is that the advice has been received, and then it falls back to the person that is trying to do this. Okay, cool. So how are we feeling about stuff so far? Are we doing okay? We're about like a little bit past our halfway point with our discussion. So hopefully this makes sense to everybody. If you're enjoying this, hit the like button or drop a comment down in the comment box to see whether you guys are enjoying this and the topics that you want to cover for the upcoming tutorials or webinars or live streams or whatever it is we want to call this. Okay, let's have a look at our next scenario. Woohoo! This one is about vintage watches. Right, okay. Wouldn't it be nice to have a vintage watch? What do you think? Does anybody have a vintage watch? Yes. Hopefully you won't have to sell your vintage watch to pay for your SQE prep. That's why we're doing this stuff online. So it's free and available. I mean, the worst thing that can happen is that you buy me a coffee, or you send me by joining the channel as a member, or you send me a super chat. But definitely you will not have to sell your vintage watch to do this. You know, it's a very cost-effective way of getting some support. Okay, let's get to our question with David. David agrees to buy a rare vintage watch from Olivia for £15,000. He believes it to be a limited edition collector's item. Now, both parties rely on an independent valuation for an expert, and the expert confirms the watch's authenticity. So the transaction goes through. David is a bit worried, though. So post the completion of the transaction, he takes the watch to another expert. The other expert discovers that this is a high quality replica and it's only worth £500. Now, David's a bit shocked here. He contacts Olivia, but she says, man, look, it ain't my fault. I really thought that the watch was genuine, and, you know, that's what the expert said. So I don't see why I should refund you. David now wants to challenge the contract on the basis of the doctrine of mistake. It's like an interesting one. Okay. So the question for you is, which type of mistake is most relevant to David's situation? Is it common mistake? That would mean that the contract is void because David and Olivia shared the same mistaken belief about the authenticity of the watch, and this was fundamental to their agreement. Is it mutual mistake? The contract is voidable because Olivia and David misunderstood each other's intentions when they were thinking about the value of the watch. Is it unilateral mistake? That the contract is still valid because David was mistaken about the watch's authenticity, but Olivia made no misrepresentations. Is it in the domain of common mistake, but it fails to work and the contract is still valid because the mistake is about attributes of the watch, not about the subject matter of the contract? Or are we talking about mutual mistake? So here the contract would be void because both parties relied on incorrect expert advice, which fundamentally altered the nature of the agreement. I don't know. What do you guys think? Are you okay with this material and the doctrine of mistake? This is another one where people normally kind of skip and they don't revise. And it is, I don't know, I don't find it particularly easy, to be honest with you, because the case law is quite complicated and it's not a topic that is normally foregrounded in the various material and sources and study guides. I do have some videos on mistake. I do have a podcast as well when I'm trying to take people through it. So I think it's worth having a look just in case it kind of pops up as a question and it sounds very confusing. The one, if you're to remember one thing about the doctrine of mistake, is that it hardly ever works. So keep this at the back of your heads. Mistake is so unlikely to be successful as an argument that usually one of the options that says it's not going to work is probably the correct option. So which one do we think is the correct option here? Okay, are we ready? The correct option here is D. We are in the era or area of common mistake, but the contract is not affected. The contract is still valid. Why is this? Okay, if I tell you that I'm selling you this, you see this? So every week I'm trying to have a prop which is usually produced either by the cats walking in front of my face or by something I find on the table. So what we've got on the table today is this creature here. So if I tell you that this is a special Pokemon that if you find it and you obtain is going to be extremely valuable, and you look at this and you're thinking, oh wow, indeed, this is like the magical Pokemon that everybody's trying to find, and I agree to sell you this for like £1,000. Now, do we, and I genuinely believe this is a unique Pokemon, yeah? Do we have any questions as to what this is? That's the actual item, right? Do we disagree as to what the item is? No, we don't. So we're talking about this thing. It's here, right? This particular one. I'm not talking about something else. I'm talking about this particular item here. So I'm talking about it. You're talking about it. We're talking about this particular item. So our mistake is not about the identity. It's not about the identity of who I am and who you are. We're not mistaken as to who's the buyer and seller. We are not mistaken as to the item we're talking about. So the mistake is not about the identity of the item either. We're talking about this specific item. What we are mistaken about is some of the background attributes about its characteristics. Now, the doctrine of mistake does not work this way. So you cannot argue mistake when you're unsure about the characteristics, but you're sure about the identity of the item. If we weren't sure about what we're talking about, so I'm talking about this and you're talking about the digital Pokemon and we completely misunderstood each other, then we would have a place for mistake. But since now we're not confused about issues of identity, but we're confused about attributes, I'm afraid mistake is not going to work. So option A that says it voids the contract is wrong. Option B that says it voids the contract is wrong. Option C that talks about unilateral is wrong on the facts because in fact it's not unilateral, they share in the mistake. Option E is also wrong. So the only one that is correct here is the one that says, yes, we're in the domain of common mistake, but the contract is still valid because the mistake was about one of the attributes of it. It was not about the identity of the item. A relevant case law here that can help you out is the case of Bell versus Lever Brothers from 1932. In addition, another shipping case is the Great Peace Shipping versus Tsavliris Salvage from 2002, where the courts spent a great deal of time trying to work out what are the boundaries and barriers of the doctrine of mistake, and they have come up to this one. Now, I don't know whether you like this as a conclusion. I think it is fair enough, because if we allow very flexible interpretations about mistake, then this would open a great deal of contracts to challenge, because most of the time we don't know what we're doing, okay? And it's very common that we make mistakes, like we order one thing because we thought it was this and turns out to be something else. So the disagreements as to the characteristics are to be dealt with through breach of contract. If express terms exist to the contract that outline the characteristics and it turns out that the goods do not match those characteristics, then we have a breach of the express terms of the contract. If, on the other hand, we have promises that have been made that are not fulfilled, so we're talking about other things, or we're talking about terms that are implied by legislation like the Sale of Goods Act or the Consumer Rights Act, so these things are again the domain of the breach of contract. If we're talking about false statements of existing fact that induce people to enter into the contract, then we're talking about misrepresentation. So wedged between breach of contract and misrepresentation, you have a very narrow area where the doctrine of mistake could still operate. So, long story short, people, it is very unlikely you're going to find a case where mistake is the correct answer. By the way, for channel members and for subscribers and for frequent visitors to the channel, have you noticed that I have rebranded? So the channel was called, the official name was Iglinavos Education, which is like a play on my name and my surname. The problem is nobody can pronounce this. So every time somebody was trying to kind of call me out or mention me in any meeting and so on, and they wanted to say the channel name, they couldn't do it. So now I'm opting for something simple. I am rebranding as Dr. Yannis, okay? So it's easy to say for the vast majority of people, it's easy to write down. And why is it Yannis and not Ioannis, which is the official name? Because people cannot say Ioannis either. So I don't know. Are you guys liking the rebranding? Do you like to think of me as Dr. Yannis? Does it make it sound friendlier, or does it make it sound like you're going in for an operation? So let me know down in the comments when you're watching this what you think about the rebrand. If everybody absolutely hates it, I can change it back to the original name. Okay, so we don't want to alienate people and they think they're going to visit their dentist. Right, are we ready for our last question for today? Yeah, okay, last question for today. What do we have? Okay, we've got Michael and the nightclub. You guys into partying? You guys into clubbing? Probably if you're getting close to the SQE, I would not advise any clubbing. But now we're safe. We passed SQE1 in January. We are making our way towards the next presentation of SQE1 in July. So perhaps in the in-between time, we can fit a little bit of clubbing, perhaps in Michael's nightclub. Yeah? All right. You guys feeling... You guys are feeling tired today? Yes. I started off tired and I'm getting worse. But we're going to plow through, because this is what we're going to do. Getting tired is no excuse to be slack in our SQE prep. So that's why we're here. Okay, now, Michael is a nightclub owner. He enters into a contract with Soundwave Limited to install new high-powered sound systems for the venue. During these negotiations, Michael tells Soundwave that he intends to operate the nightclub at the maximum of the capacity of the sound system, which probably breaches permitted noise levels. Yeah. So there are environmental regulations in councils that limit the amount of noise that you can have from your property, even if you've got a club or a bar or a venue, right? And there are also times that you need to stop and all of that stuff. So Soundwave knows this and knows that Michael is probably going to be a little bit dodgy, but they sell him the sound system anyway. They sell it, they install it, it works. It turns out that the neighbors are upset with Michael and all the noise, so the local council shuts down the nightclub. Michael has now ceased operations. Michael had yet to pay the invoice from Soundwave, so now, cheeky bugger as he is, he says, I'm not going to pay you because you supplied me equipment that is operating illegally and the council has come and shut me down. So our contract is not enforceable due to illegality. I mean, you got to give it to Michael, right? Would you guys have thought of this as a way to get out of paying your invoices? I think it's an excellent idea. So the question for you is, under English contract law, what principle of illegality is most relevant in determining whether Soundwave can enforce the contract? So it's Soundwave trying to enforce because they are the ones who are unpaid for the sound system. So A, contracts that involve illegal activity or breach of the law are generally unenforceable, meaning Michael does not have to pay. B, contract remains invalid even if it leads to valid even if it leads to an illegal act, as long as the subject matter of the contract does not break the law at the time of formation. C, Michael can refuse to pay because Soundwave had an equal duty to ensure the nightclub complied with the law and proceeded despite knowing the risks. D, a contract is only unenforceable for illegality if it involves a criminal act, meaning Soundwave can still sue for breach of contract for the non-payment. E, the court will always allow a claim for breach of contract, even if the contract involved an illegal purpose, as defying an enforcement would be unfair. Okay, what do we think about this? Do we think that Michael is going to get away with it, and for what reason? Yeah? Right. Let me ask you this. Is it illegal to sell sound systems? No. Okay, it isn't. I mean, you can sell speakers, you can sell sound systems, you can sell whatever you want. You know what, to be honest, even if the sound system had a setting that the volume was only massive, I think even then you would struggle to say that selling a sound system is illegal. Certain things are not legal, or the contracts can only be legal in specific circumstances. So class A drugs, you cannot sell to people without having specific licenses. Certain things you cannot sell at all. Yeah. There are certain types of weapons or munitions that are not allowed to be sold at all because they're considered violations of international law. So there are, if you manufacture bombs that contain toxic chemicals, then these are just certain types of them cannot be sold at all because the law entirely prohibits them. So we have various categories of why things may be problematic. We've got areas that the sale is completely illegal. We've got areas where the sale might be legal for specific categories of sellers. And we've got areas where the sale might be legal for both specific categories of sellers and buyers. If we are under such a regulatory, it doesn't have to be criminal, it can be regulatory. If we're under such a regulatory prohibition, then in fact, the contract is not an enforceable contract if the subject matter is illegal. Yeah. So one could refuse to pay an invoice or refuse to accept a service if what is the underlying subject matter of the contract is illegal. How do we know this? We know this all the time, and we know this usually through sanctions. That you had already a contract that you can no longer perform because you have been banned. The government has said you cannot deal with these people or with this entity or with this country anymore. We've got cases where They have criminalized various things that were okay up until now, saying that you've got a vape shop, you're selling vapes to kind of little kids, yes, and the government suddenly comes to its senses and bans this. So if you had future supply agreements, now these are illegal because your people are not allowed to sell that stuff anymore. So you could argue that these contracts are illegal. One of the areas where we come across this is the area of frustration of contract, because very often people will argue that for contracts already done that can no longer be performed to a change in the law, that change in the law counts as a frustrating event. So this takes the majority of the domain of illegality in relation to contracting. But we also have got certain cases where illegality might be used as a reason not to perform the contract, outside a discussion on the doctrine of frustration. So the thing, though, is that the subject matter of the contract needs to be the one that raises the illegality, not choices about its use. Okay, so can I come over there and stab you in the eye with this pen? No, okay, because that would be assault. But can we say that the manufacturer of this pen is at fault? Or that I ordered this from Amazon, could I just say that my contract with Amazon has been rendered illegal because I was looking for a pen to stab somebody in the eye with it? No, because the illegality comes from my choices in my actions that are unrelated to the contract. Similarly here, Michael buying a sound system for his venue doesn't have anything to do with the fact that he used it in an illegal way. Yes, it could be that he had taken the sound system and smashed somebody over the head with it. It's not the fault of the people who sold him the sound system. So I don't really see how we could make an argument here that illegality has something to do with the refusal to pay the invoice. So now I'm going to give it to him. That's a very, some innovative solicitor came up with this suggestion. So, hats off to them, but it's actually has no basis in the law. So this is not going to work. So the correct answer here is B. The contract remains valid, even if it leads to an illegal act, because the illegal act doesn't have anything to do with the contract itself, right? So, again, hats off to the lawyer who thought of this as a way to kind of non-payment on the invoice, but in fact, it's not going to work. So the rest of them are also wrong. Contracts that involve ACEs, contracts that involve the illegal activity or breach of law are generally unenforceable. Well, I mean, it depends what we're talking about, right? So as a broad statement, this is not specific enough to be an appropriate answer. The C that says Michael can refuse to pay because Soundwave has an unequal duty. No, they don't. Okay, this is not the sale of sound systems is not the regulated area. If they were selling kind of uranium for nuclear reactors, then yeah, it would be regulated. But this is a sound system, it's like generic consumer goods. D is that says that the contract is only unenforceable for illegality if it involves a criminal act. No, because as I said, there's a whole swathe of regulatory restrictions that might render the performance of a contract illegal. It doesn't mean that it has to be criminal. And E said that the court will always allow a claim for breach of contract, even if it was for an illegal purpose, because otherwise it would be unfair. But no, that's just clearly wrong. Okay, so I think it's the challenge with this question is more the fact that it just looks so strange that it might make you wonder. And I think this happens, right? We come across questions from what we know about the SQE that are meant to kind of throw you off because it's something that is unanticipated and you really didn't think it was going to work that way. So when it hits you, you're confused. Remember, you got like a minute to think about a potential answer. If you're confused, it delays you or it gets you to kind of pick something else, and that kind of increases the risk that you get it wrong. So fight through the confusion and try and think clearly to the extent possible in the time that you've got. Illegality is small part, same as I said for mistake. They're both small parts of what we can do in the law of contract. It doesn't come up very often. You should be aware of them so you can tackle them when you find them. But apart from an appreciation of the doctrines and their use, something that leads to a finding of mistake or a finding of illegality is unlikely. The stuff that we started off with, duress and undue influence to an extent and misrepresentation are way more prominent as real reasons to stop people's contracts. So, guys, we've reached the end of our session for today. So, thank you so much for turning up. It was great to have people live. Thank you, Maria, for the interaction in the chat. That's just lovely. Everybody else who's watching this on the replay, feel free to put comments down in the description, and I will reply to all those comments so we can have a discussion. And I will see you guys next week for our next live stream, so we can all get together, have some fun, and kind of battle through the SQE horror with a sense of community. So thank you all so much, and I'll see you guys next time.